A castle doctrine, also known as a castle law or a defense of habitation law, is a legal doctrine that designates a person's abode or any legally occupied place, e.g., a vehicle or home, as a place in which that person has protections and immunities permitting one, in certain circumstances, to use force, up to and including deadly force, to defend oneself against an intruder, free from legal prosecution for the consequences of the force used. The term is most commonly used in the United States, though many other countries invoke comparable principles in their laws. A person may have a duty to retreat to avoid violence if one can reasonably do so. Castle doctrines negate the duty to retreat when an individual is assaulted in a place where that individual has a right to be, such as within one's own home. Deadly force may be justified and a defense of justifiable homicide applicable, in cases when the actor reasonably fears imminent peril of death or serious bodily harm to him or herself or another. The Castle Doctrine is not a defined law that can be invoked, but a set of principles which may be incorporated in some form in the law of many jurisdictions. Justifiable homicide inside one's home is distinct, as a matter of law, from Castle Doctrine because the mere occurrence of trespassing and occasionally a subjective requirement of fear is sufficient to invoke the Castle Doctrine. The burden of proof of fact is much less challenging than that of justifying a homicide. With a mere justifiable homicide law, one generally must objectively prove to a trier of fact, beyond all reasonable doubt, the intent in the intruder's mind to commit violence or a felony. It would be a misconception of law to infer that because a state has a justifiable homicide provision pertaining to one's domicile, it has a Castle Doctrine, exonerating any duty whatsoever to retreat therefrom. The use of this legal principle in the United States has been controversial in relation to a number of cases in which it has been invoked, including the deaths of Japanese exchange student Yoshihiro Hattori and Scottish businessman Andrew de Vries. History. The legal concept of the inviolability of the home has been known in Western civilization since the age of the Roman Republic. In English common law, the term is derived from the dictum that an Englishman's home is his castle, see Seamayne's case. This concept was established as English law by the 17th-century jurist Sir Edward Coke, in his The Institutes of the Laws of England, 1628. For a man's house is his castle, et domus sua quique est tutissimum refugium. English common law came with colonists to the New World, where it has become known as the Castle Doctrine. The term has been used in England to imply a person's absolute right to exclude anyone from their home, although this has always had restrictions, such as bailiffs having increasing powers of entry since the late 20th century. According to 18th-century Presbyterian minister and biblical commentator Matthew Henry, the prohibition of murder found in the Old Testament contains an exception for legitimate self-defense. A home defender who struck and killed a thief caught in the act of breaking in at night was not guilty of bloodshed. If a thief is caught breaking in and is struck so that he dies, the thief owes no blood debt to the home defender, but if the thief lives, he owes a blood debt to the home defender and must make restitution. In early United States. By the 18th century, many U.S. state legal systems began by importing English common law such as Acts of Parliament of 2 ed. 3, Statute of Northampton, and 5 Rich. 2, Forcible Entry Act 1381, in law since 1381, which imposed criminal sanctions intending to discourage the resort to self-help. This required a threatened party to retreat, whenever property was involved, and resolve the issue by civil means. Then as now, there were English politicians who were for or against the use of self-help over state help. William Blackstone, in Book 4, Chapter 16 of his Commentaries on the Laws of England, proclaims that the laws leave him, the inhabitant, the natural right of killing the aggressor, the burglar, and goes on to generalize in the following words. And the law of England has so particular and tender a regard to the immunity of a man's house, that it styles it his castle, and will never suffer it to be violated with immunity, agreeing herein with the sentiments of ancient Rome, as expressed in the works of Tully, quid enim sanctius, quid omni religioni munitius, quam domus unius quisque civium. For this reason no doors can in general be broken open to execute any civil process, though, in criminal causes, the public safety supersedes the private. Hence also in part arises the animadversion of the law upon eavesdroppers, nuisanceurs, and incendiaries, and to this principle it must be assigned, that a man may assemble people together lawfully without danger of raising a riot, rout, or unlawful assembly, in order to protect and defend his house, which he is not permitted to do in any other case. William Blackstone, Commentaries on the Laws of England. Not only was the doctrine considered to justify defense against neighbors and criminals, but any of the Crown's agents who attempted to enter without a proper warrant as well. It should be noted that prohibitions of the Fourth Amendment to the United States Constitution share a common background with current Castle Doctrine laws. In 1841, the Preemption Act was passed to appropriate the proceeds of the sales of public lands, and to grant preemption rights to individuals who were already living on federal lands, commonly referred to as squatters. During this same period, claim clubs sprung up all over the U.S. advocating vigilance and the Castle Doctrine. This was in concurrence with the culture of manifest destiny which led to westward expansion and the American Indian Wars, the last of which ended by the 1920s. On the American frontier. On the American frontier, the doctrine of no duty to retreat extended outside a residence. It asserted that a man in an altercation that he did not provoke was not obliged to flee from his attacker, but was free to stand his ground and defend himself. A state Supreme Court justice wrote in 1877. Indeed, the tendency of the American mind seems to be very strongly against the enforcement of any rule which requires a person to flee when assailed. American West historian Richard M. Brown wrote that under the circumstances, for a man in the American West to flee under such circumstances would be cowardly and un-American. Legendary dentist and gambler Doc Holliday successfully used this defense when he shot Billy Allen as he entered a saloon. Holliday owed Allen $5 which Allen wanted paid and had threatened Holliday. Although Allen was unarmed at the time, Holliday had received reports that Allen had been armed and looking for him earlier in the day. During the subsequent trial, Holliday asserted he was within his rights and the jury agreed. He was acquitted on March 28, 1885. Current position. Today, the penal and civil forcible entry laws of most American states forbid the use of force in the recovery of possession of land. A minority of states, however, permit individuals who have the right of immediate possession of land to use reasonable force to regain possession of that land. The term "make my day law" came to be used in the United States in about 1985 when Colorado passed a law that shielded people from any criminal or civil liability for using force against a home invader, including deadly force. The law's nickname is a reference to the line "Go ahead, make my day," meaning do something so I have an excuse to kill you, uttered by actor Clint Eastwood's character Dirty Harry Callahan in the 1983 police film Sudden Impact. Conditions of use. Each jurisdiction incorporates the Castle Doctrine into its laws in different ways. The circumstance in which it may be invoked include the premises covered, abode only, or other places too, the degree of retreat or non-deadly resistance required before deadly force can be used, etc. Typical conditions that apply to some Castle Doctrine laws include: an intruder must be making, or have made, an attempt to unlawfully or forcibly enter an occupied residence, business, or vehicle. The intruder must be acting unlawfully. The Castle Doctrine does not allow a right to use force against officers of the law, acting in the course of their legal duties. The occupant, of the home must reasonably believe the intruder intends to inflict serious bodily harm or death upon an occupant of the home. Some states apply the Castle Doctrine if the occupant, of the home reasonably believe the intruder intends to commit a lesser felony such as arson or burglary. The occupant, of the home must not have provoked or instigated an intrusion, or provoked/instigated an intruder's threat or use of deadly force. In all cases, the occupant, of the home, must be there legally, must not be fugitives from the law, themselves, or aiding/abetting other fugitives, and must not use force upon an officer of the law performing a legal duty. In Colorado, the Make My Day statute provides the occupant with immunity from prosecution only for force used against a person who has made an unlawful entry into the dwelling, but not against a person who remains unlawfully in the dwelling. Immunity from civil lawsuit. In addition to providing a valid defense in criminal law, many laws implementing the Castle Doctrine, particularly those with a stand your ground clause, also have a clause which provides immunity from any civil lawsuits filed on behalf of the assailant, for damages/injuries resulting from the force used to stop them. Without this clause, an assailant could sue for medical bills, property damage, disability, and pain and suffering as a result of the injuries inflicted by the defender, or, if the force results in the assailant's death, his/her next of kin or estate could launch a wrongful death suit. Even if successfully rebutted, the defendant, the homeowner/defender, may still have to pay high legal costs leading up to the suit's dismissal. Without criminal/civil immunity, such civil action could be used as revenge against a lawfully acting defender, who was, originally, the assailant's victim. Use of force in self-defense which causes damage or injuries to other, non-criminally acting parties, may not be shielded from criminal or civil prosecution, however. Duty to retreat. In U.S. jurisdictions where the Castle Doctrine applies, there is no duty to retreat before deadly force is used against an intruder by a person in their home or, in some jurisdictions, just simply where the person can legally be. Stand your ground. Most states in the United States have stand your ground laws where individuals can use deadly force in any location one is legally allowed to be without first attempting to retreat. Culpability of intruder. In Colorado, the Make My Day statute was not intended to justify use of physical force against persons who enter a dwelling accidentally or in good faith. In other words, the unlawful entry element requires a culpable mental state of knowingly on the part of the intruder. State-by-state positions in the United States. For each state in the U.S. with a Castle Doctrine, an external link is provided to the text of the specific statute, if available. If a direct link is unavailable, for example if the destination website uses JavaScript, the statute name and/or number is listed. States with a Castle Law. Castle Doctrine lays down that there is no duty to retreat from an intruder in one's home. A justifiable homicide which occurs inside one's home is distinct as a matter of law from Castle Doctrine's no duty to retreat. As such, states with justifiable homicide provisions in pertaining to one's domicile, do not in themselves authorize indiscriminate violence therein. The mere fact that one is trespassing is no defense per se to justifying homicide. In addition to the states listed below, the U.S. territory of Guam has the Castle Doctrine as law. State statute notes. Alabama 13A3-23 Use of force in defense of a person. A person is justified in using physical force upon another person in order to defend himself or herself or a third person from what he or she reasonably believes to be the use or imminent use of unlawful physical force by that other person, and he or she may use a degree of force which he or she reasonably believes to be necessary for the purpose. A person may use deadly physical force, and is legally presumed to be justified in using deadly physical force in self-defense or the defense of another person pursuant to subdivision 4, if the person reasonably believes that another person is, 1. Using or about to use unlawful deadly physical force. 2. Using or about to use physical force against an occupant of a dwelling while committing or attempting to commit a burglary of such dwelling. 3. Committing or about to commit a kidnapping in any degree, assault in the first or second degree, burglary in any degree, robbery in any degree, forcible rape or forcible sodomy. 4. In the process of unlawfully and forcefully entering, or has unlawfully and forcefully entered, a dwelling, residence, or occupied vehicle, or federally licensed nuclear power facility, or is in the process of sabotaging or attempting to sabotage a federally licensed nuclear power facility, or is attempting to remove, or has forcefully removed, a person against his or her will from any dwelling, residence, or occupied vehicle when the person has a legal right to be there, and provided that the person using the deadly physical force knows or has reason to believe that an unlawful and forcible entry or unlawful and forcible act is occurring. http://www.asakari.com/alabama_stand_your_ground_castle_doctrine_law.html Alaska 11.81.335, a person who is justified in using non-deadly force in self-defense under as 11.81.330 may use deadly force in self-defense upon another person when and to the extent the person reasonably believes the use of deadly force is necessary for self-defense against death, serious physical injury, kidnapping, sexual assault, robbery in any degree. There is no duty to leave the area if the person is 1. On premises that the person owns or leases. See more at http://codes.lp.findlaw.com/actstatutes/11/11.81.335 numbers thosh.q41t1xxm.gov. Arizona 13-411A. A person is justified in threatening or using both physical force and deadly physical force against another if and to the extent the person reasonably believes that physical force or deadly physical force is immediately necessary to prevent the other's commission of arson of an occupied structure under Section 131704, burglary in the second or first degree under Section 131507 or 131508, kidnapping under Section 131304, manslaughter under Section 131103, second or first degree murder under Section 131104 or 131105, sexual conduct with a minor under Section 131405, sexual assault under Section 131406, child molestation under Section 131410, armed robbery under Section 131904, or aggravated assault under Section 131204, subsection A, paragraphs 1 and 2. B. There is no duty to retreat before threatening or using physical force or deadly physical force justified by subsection A of this section. C. A person is presumed to be acting reasonably for the purposes of this section if the person is acting to prevent the commission of any of the offenses listed in subsection A of this section. D. This section is not limited to the use or threatened use of physical or deadly physical force in a person's home, residence, place of business, land the person owns or leases, conveyance of any kind, or any other place in this state where a person has a right to be. Arkansas. The General Assembly finds that the current laws regarding self-defense and the use of deadly physical force in self-defense or in defense of another person are adequate in that the law explicitly does not require a person to retreat from certain life-threatening confrontations if a person cannot do so safely. However, the General Assembly finds that there is currently not enough protection from civil liability for a person who rightfully uses deadly physical force in self-defense or in defense of another person. The General Assembly finds that a more robust civil immunity statute is necessary to protect a person from civil damages stemming from an incident when he or she lawfully uses deadly physical force in self-defense or in defense of another person. California Penal Code 198.5. Any person using force intended or likely to cause death or great bodily injury within his or her residence shall be presumed to have held a reasonable fear of imminent peril of death or great bodily injury to self, family, or a member of the household when that force is used against another person, not a member of the family or household, who unlawfully and forcibly enters or has unlawfully and forcibly entered the residence and the person using the force knew or had reason to believe that an unlawful and forcible entry occurred. Colorado 18-1-704, any occupant of a dwelling is justified in using any degree of physical force, including deadly physical force, against another person when that other person has made an unlawful entry into the dwelling, and when the occupant has a reasonable belief that such other person has committed a crime in the dwelling in addition to the uninvited entry, or is committing or intends to commit a crime against a person or property in addition to the uninvited entry, and when the occupant reasonably believes that such other person might use any physical force, no matter how slight, against any occupant. Connecticut Sector 53A20. A person in possession or control of premises, or a person who is licensed or privileged to be in or upon such premises, is justified in using reasonable physical force upon another person when and to the extent that he reasonably believes such to be necessary to prevent or terminate the commission or attempted commission of a criminal trespass by such other person in or upon such premises, but he may use deadly physical force under such circumstances only, 1. In defense of a person as prescribed in Section 53A19, or 2. when he reasonably believes such to be necessary to prevent an attempt by the trespasser to commit arson or any crime of violence, or 3. To the extent that he reasonably believes such to be necessary to prevent or terminate an unlawful entry by force into his dwelling as defined in Section 53A 100, or place of work, and for the sole purpose of such prevention or termination. Delaware: no duty to retreat in home. Duty to retreat in public. Florida: 776.013 Home protection, use or threatened use of deadly force, presumption of fear of death or great bodily harm. Georgia: 16-3-23.1 No duty to retreat prior to use of force in self-defense. Hawaii: 703-304 No duty to retreat from dwelling/workplace. Idaho: 18-4009 A justifiable homicide law in self-defense from violence must prove intruder's intent thereof. Illinois: 720 ILCS 5 Use of deadly force justified. Specific legislation prevents filing claim against defender of dwelling. Illinois has no requirement of retreat. Indiana: IC 35-41-3-2 No duty to retreat from dwelling, curtilage, or occupied motor vehicle. In 2012, an amendment was made to the code to address the issue of force against a public servant. The amendment states, a person is not justified in using deadly force against a public servant whom the person knows or reasonably should know is a public servant unless 1. The person reasonably believes that the public servant is a. Acting unlawfully, or b. Not engaged in the execution of the public servant's official duties, and 2. The force is reasonably necessary to prevent serious bodily injury to the person or a third person. Iowa: 704.1 No duty to retreat from home or place of business in defense of self or a third party. Kentucky: KRS 503.055 No duty to retreat from dwelling, residence, or occupied vehicle. Louisiana: LARS 1420, 4a. When committed by a person lawfully inside a dwelling, a place of business, or a motor vehicle as defined in RS 32:1, 40, against a person who is attempting to make an unlawful entry into the dwelling, place of business, or motor vehicle, or who has made an unlawful entry into the dwelling, place of business, or motor vehicle, and the person committing the homicide reasonably believes that the use of deadly force is necessary to prevent the entry or to compel the intruder to leave the premises or motor vehicle. Maine: 104 Deadly force justified to terminate criminal trespass and another crime within home, or to stop unlawful and imminent use of deadly force, or to effect a citizen's arrest against deadly force, duty to retreat not specifically removed. Maryland: see Maryland self-defense. Case law, not statute, incorporates the common law Castle Doctrine into Maryland self-defense law. Invitees or guests may have duty to retreat based on mixed case law. Massachusetts: 278-8 A Section 8a. In the prosecution of a person who is an occupant of a dwelling charged with killing or injuring one who was unlawfully in said dwelling, it shall be a defense that the occupant was in his dwelling at the time of the offense and that he acted in the reasonable belief that the person unlawfully in said dwelling was about to inflict great bodily injury or death upon said occupant or upon another person lawfully in said dwelling, and that said occupant used reasonable means to defend himself or such other person lawfully in said dwelling. There shall be no duty on said occupant to retreat from such person unlawfully in said dwelling. Michigan: 768.21c 768.21c Use of deadly force by individual in own dwelling, dwelling defined. 1. In cases in which Section 2 of the Self-Defense Act does not apply, the common law of this state applies except that the duty to retreat before using deadly force is not required if an individual is in his or her own dwelling or within the curtilage of that dwelling. 2. As used in this section, dwelling means a structure or shelter that is used permanently or temporarily as a place of abode, including an appurtenant structure attached to that structure or shelter. Minnesota: 609.065 No duty to retreat before using deadly force to prevent a felony in one's place of abode, no duty to retreat before using deadly force in self-defense in one's place of abode. This isn't as clear as it appears, however. There are 4 cases in Minnesota where duty of retreat was upheld. Mississippi MS Code March 15, 97, 3. A person who uses defensive force shall be presumed to have reasonably feared imminent death or great bodily harm, or the commission of a felony upon him or another or upon his dwelling, or against a vehicle which he was occupying, or against his business or place of employment or the immediate premises of such business or place of employment, if the person against whom the defensive force was used, was in the process of unlawfully and forcibly entering, or had unlawfully and forcibly entered, a dwelling, occupied vehicle, business, place of employment or the immediate premises thereof, or if that person had unlawfully removed or was attempting to unlawfully remove another against the other person's will from that dwelling, occupied vehicle, business, place of employment or the immediate premises thereof, and the person who used defensive force knew or had reason to believe that the forcible entry or unlawful and forcible act was occurring or had occurred. This presumption shall not apply if the person against whom defensive force was used has a right to be in or is a lawful resident or owner of the dwelling, vehicle, business, place of employment or the immediate premises thereof, or is the lawful resident or owner of the dwelling, vehicle, business, place of employment or the immediate premises thereof, or if the person who uses defensive force is engaged in unlawful activity, or if the person is a law enforcement officer engaged in the performance of his official duties. 4. A person who is not the initial aggressor and is not engaged in unlawful activity shall have no duty to retreat before using deadly force under subsection 1, e, or f, of this section if the person is in a place where the person has a right to be, and no finder of fact shall be permitted to consider the person's failure to retreat as evidence that the person's use of force was unnecessary, excessive, or unreasonable. 5. A. The presumptions contained in subsection 3 of this section shall apply in civil cases in which self-defense or defense of another is claimed as a defense. Missouri 563.031 extends to any building, inhabitable structure, or conveyance of any kind, whether the building, inhabitable structure, or conveyance is temporary or permanent, mobile or immobile, e.g., a camper, RV, or mobile home, which has a roof over it, including a tent, and is designed to be occupied by people lodging therein at night, whether the person is residing there temporarily, permanently, or visiting, e.g., a hotel or motel, and any vehicle. The defense against civil suits is absolute and includes the award of attorney's fees, court costs, and all reasonable expenses incurred by the defendant in defense of any civil action brought by a plaintiff. Montana 45-3-103 45-3-103. Use of force in defense of occupied structure. 1. A person is justified in the use of force or threat to use force against another when and to the extent that the person reasonably believes that the use of force is necessary to prevent or terminate the other person's unlawful entry into or attack upon an occupied structure. 2. A person justified in the use of force pursuant to subsection 1 is justified in the use of force likely to cause death or serious bodily harm only if a. The entry is made or attempted and the person reasonably believes that the force is necessary to prevent an assault upon the person or another then in the occupied structure, or b. The person reasonably believes that the force is necessary to prevent the commission of a forcible felony in the occupied structure. Nebraska: no duty to retreat in home. Duty to retreat in public. Nevada 200.120 200.120. 1. Justifiable homicide is the killing of a human being in necessary self-defense, or in defense of habitation, property, or person, against one who manifestly intends or endeavors, by violence or surprise, to commit a felony, or against any person or persons who manifestly intend and endeavor, in a violent, riotous, tumultuous, or surreptitious manner, to enter the habitation of another for the purpose of assaulting or offering personal violence to any person dwelling or being therein. 2. A person is not required to retreat before using deadly force as provided in subsection 1 if the person a. is not the original aggressor, b. has a right to be present at the location where deadly force is used, and c. is not actively engaged in conduct in furtherance of criminal activity at the time deadly force is used. New Hampshire: not required to retreat if he or she is within his or her dwelling, its curtilage, or anywhere he or she has a right to be, and was not the initial aggressor. An individual may respond to a threat of serious bodily injury or death by displaying a firearm or other method of self-defense. Deadly force is justified if the aggressor is about to use unlawful, deadly force, is likely to use any unlawful force against a person present while committing or attempting to commit a burglary, is committing or about to commit kidnapping or a forcible sex offense, or is likely to use any unlawful force in the commission of a felony against the individual within their dwelling or its curtilage. New Jersey retreat required if actor knows he can avoid necessity of deadly force in complete safety, etc. except not obliged to retreat from dwelling, unless the initial aggressor. New York PL 35.15, 2, a, I, retreat required if actor knows that with complete personal safety, to oneself and others, he or she may avoid the necessity of using deadly force by retreating, except that the actor is under no duty to retreat if he or she is in his or her dwelling and not the initial aggressor. North Carolina 1451.3 Use of force in defense of person, relief from criminal or civil liability. A person is justified in using force, except deadly force, against another when and to the extent that the person reasonably believes that the conduct is necessary to defend himself or herself or another against the other's imminent use of unlawful force. However, a person is justified in the use of deadly force and does not have a duty to retreat in any place he or she has the lawful right to be if either of the following applies. 1. He or she reasonably believes that such force is necessary to prevent imminent death or great bodily harm to himself or herself or another. 2. Under the circumstances permitted pursuant to GS 1451.2. b. A person who uses force as permitted by this section is justified in using such force and is immune from civil or criminal liability for the use of such force, unless the person against whom force was used is a law enforcement officer or bail bondsman who was lawfully acting in the performance of his or her official duties and the officer or bail bondsman identified himself or herself in accordance with any applicable law or the person using force knew or reasonably should have known that the person was a.
Please subscribe and thanks for watching.